I know how.
Welcome to Education Policy Committee meeting today. If you have not turned your phone on silent, I ask you to do so. And I'd like to ask Representative Fincher to open us in prayer before we begin.
If you would, please bow your heads. Our Father, we thank you for this day. We thank you for your gifts that you give us, the ability to be up and about each day and seeking to do your will. As we go through this meeting, give us discernment, give us an open mind, give us a willingness to do and say those things that would be pleasing to you. Now watch over us and be gentle and kind toward us as we try to be gentle and kind toward one another. These things we ask in the name of your Son, Jesus Christ. Amen.
Amen. Thank you very much. Clerk will call the roll.
Representative Collins.
Here.
Representative Baker.
Here.
Representative Drummond. Representative Daniels. Representative DuBose. Representative Estes. Representative Fincher. Representative Gidley. Representative Gray. Representative Holk-Jones. Representative Morris. Representative Paramore. Representative Pascal. Representative Smith. Representative Woods. A quorum is present.
Thank you. Representative Estes, I believe you have some guests.
I have a couple of pages with me this week, both from my hometown in Winfield, from Winfield City High School. If they'd both stand up. We have Jack Hayden Cook, who is a freshman at Winfield City High School, and Jacob Chisholm, who is a sophomore. So they've been with us this week and been a lot of help.
Good to have you with us today. I have the bill, the only bill. We have a public hearing, and so I'm going to turn the gavel over to, that I never use, over to Vice Chair Alan Baker.
Thank you, Madam Chair. We do have the one bill on our agenda for today, which is HB 269, which there's been a public hearing that's been called on this bill, and just sort of set out the parameters in regards to the public hearing. I will alternate between the opponents and proponents, and allow then each of those that has signed up to speak, then 3 minutes. And Adam, would you be able to somewhat give maybe with a 30-second warning or something on that, on the 3-minute time frame? There will not be a vote taken on the bill today, so I did want to make that clear at the very forefront. So with that, then I would open the public hearing. And first, Representative Collins, Madam Chair. Then actually, we need the sponsor of the bill maybe to first give us any briefing that you would care in advance of the public hearing. My apologies.
No, thank you very much. And with your permission, I'll just stay right here since speakers will come from the audience. If you've been on this committee, we've seen it a few times in the past, and we've been working on it to try to get to a spot that will make us happy. But I appreciate especially Representative Fincher's prayer about an open mind, because here's what I want you to hear, and here's my goal with this, is that the bill starts with 5 declarations that I agree with each and every one of those. I think students need to be in classrooms to learn. And so, but I also know from what I'm hearing around all over the state, discipline is really one of the biggest needs. We had an earlier committee where we moved Representative Baker's bill about principals, and I think improving that system will make a big difference. But in this bill, one of the words that comes out is consistent, appropriate discipline. And that's my goal with this one. And so as I walk through it and you look at the meanings, it's focused on expulsions, which is more than 90 days. So I want us to keep that in mind when we're here in discussion. So we're talking about students not being in school for more than 90 days. And then long-term suspensions, which are less than 90, but more than 10 days. So this is a long time, and that's the focus of what this bill is about. I will be listening and taking good notes on things I think would be important to people, but being consistent and being appropriate and having something that we can all work with to know the basis, I think is a good start and has a lot of good meaning. So after the public hearing, I'm happy to answer any questions.
Thank you, Madam Chair. With that, then, I will go ahead and begin the public hearing. First would be an opponent, Jane Williams. If you don't mind, if you would just, I've already stated your name, but if you'll just, for others then, state the entity as well. Thank you.
Thank you, Vice Chair Baker and the Chair Collins and members of the committee. I'm Jane Williams, General Counsel of the Alabama Association of School Boards. And we have done a lot of work and I've been here several times. I don't want to come back. But thank you to the sponsors of the legislation. And we are close. We've done a lot of work with you all the last 3 years. Now we'll quickly hit our final concerns, and we hope we can get this through. At line 77, we support limiting serious discipline to the older students because we do think it's important to keep as many kids in class as possible. But we do want to limit that based on age rather than grade because not all fifth graders are 10 years old. So we want to make that older limit based on age. In that same section, you have that we can discipline younger students for danger to the person or property, but we want to add substantial disruption to the educational environment. This is only as a last resort so that we can educate our kids, which is what we're ultimately there to do. At lines 103 and 104, and by the way, I do have a list of these because I'm going to go pretty fast so we can get under my time limit. I'm afraid of the bill. So if I go too fast, I do have a list if you need it. 103 and 104, the local board can appoint a neutral designee to be the hearing officer, but the parent has to agree to that. We don't think that's a reasonable requirement, especially with the tight timelines in this bill. At line 108, if we don't hear back from the parent once they get the notice, we think that hearing should be waived. At line 115, we'd like to drop the requirement to identify witnesses, especially for our student witnesses. And at 143, we want to drop the requirement to allow cross-examination. Due process is defined as notice of what we said you did wrong and an opportunity to be heard. The Constitution does not require cross-examinations in student hearings. Expecting children to undergo this type of scrutiny and cross-examination and potentially retaliation means they will not come forward when we need them to, when one of their peers has done something wrong. And we all know the consequences of kids not coming forward to report things can be deadly. That is just a fact. Finally, at lines 139 and later at 174, we're required to offer evidence of the student's intent. I challenge any parent in this room to explain why children behave the way that they behave sometimes. It's unreasonable to expect school administrators to do so in this context. One final thing on a personal note. I graduated from a public school right down the street in 1992. Go Poets. These are my public school sons. I'm going to leave this room, go sit in the carpool line for a full hour. Thank you. I will try to stay awake. But I know that that's how we all win, by keeping kids in school. That's what we want to do. That's our goal. But we have to be smart about how we do this. We've been fighting for this for 3 years. I know I went fast. I have a copy of our proposals if anybody wants to review them, and I'm here for questions if you need them. Thank you very much.
Thank you, Ms. Williams. Next, a proponent, Jerome Dees. And Mr. Dees, of course, I know you and I know each other, but for the I guess the public here as well for the members of the committee, then if you'll identify your entity as well, please.
Absolutely. Jerome Dees with the Southern Poverty Law Center. We've been here, as has been stated, for several years. For a number of you, I've traveled to your district or gone to your office to try and sit down and go through the bill and walk through point by point the do's and don'ts of the bill. In previous years when I've come up here, I've shared case stories of students that have suffered as a result of lack of due process, but I won't go through that this time. I just want to talk about the legislative process itself. When an issue comes up across the state, regardless of what that issue is, bill obviously gets drafted, and if there are opposing viewpoints on what that bill is, oftentimes a public hearing is called. And the purpose of that public hearing is for those opposing viewpoints to be heard and try to arrive at some general sense of understanding of exactly what the issues are and how you as a deliberative body move forward from that point. That's all that we are seeking with this particular bill. The opportunity for when issues arise in classrooms where there may be differing or disparate opinions as to what has taken place in that classroom, to give parents notice that this allegation has been made against their child. The opportunity for them, that family, to then present evidence on their own behalf. The opportunity, yes, in fact, to question adverse witnesses. And again, I know there has been a lot of discussion and a lot of concern raised about that particular point. And that is one of the big reasons why an amendment was offered just in the past couple of weeks that excludes children under the age of 14 from that cross-examination purpose. Now, and the reason that the age of 14 was chosen is because when we're dealing with truly serious and significant issues, like if a child is alleged to have brought a gun to a classroom or has brought a controlled substance on campus, oftentimes those instances are going to be correlated with some sort of other criminal action as well. And so if you've got a witness, a student witness that's going to be brought in, 9 times out of 10, they're going to have to testify in that situation as well. And so that's where we came up with the idea of kind of 14 being a cutoff, where they're already going to be brought into a courtroom setting to have to speak to the issues on that anyways. Again, I've tried to make myself available to all parties really over the past 2 years. Developed a good relationship with the school board, and I'm disappointed that you didn't claim LAMP as your high school graduation. But again, I remain open to any questions or concerns that the body has and to try to kind of walk through point by point exactly what this bill does and, importantly, what it does not do. Thank you again for your time.
Thank you for your remarks, Mr. Dees, and we will allow an opportunity at the end to call back any of those that have spoken then or for any questions from any of the committee members. Our last speaker would be an opponent, Ryan Hollingsworth.
Good afternoon. Ryan Hollingsworth, School Superintendents of Alabama. I'm the Executive Director. And I think, I don't know how many years, it's been several, this bill has been in this committee, and I've spoken in opposition to it each and every year. Every year we've tried to work on our differences and get to a point where we could agree, but this year upstairs we've worked as well and have not been able to agree upstairs. Down here may be a different matter. So what I've done this year a little bit different is I went back and looked at some data, because what this bill talks about, Representative Collins talks about the long-term suspension and expulsion. So I went back and looked at the SIR data. If you're in education, you know what that is. The most recent full year was 2021 that was verified and certified. In the state of Alabama, we had 143 total expulsions and 103 long-term suspensions. In total, we had 246 either long-term suspensions or expulsions out of 725,000 students. So that's 0.03%. It's not very many. 246 is too many, I agree. But in this large scheme of 725, it's not a lot. So then I looked to the section of lines 77 through 83 that would prohibit a school from suspending a child in pre-K through 5th grade for the reasons are listed. So I looked at that SIR data. Also, in my opinion, these are the things that we suspended kids for in 2021 that we could not suspend them for if the bill passed, and I want to share those with you. Disorderly conduct, willful and persistent disobedience, defiance of authority, profanity or vulgarity, tobacco use or possession, theft, inappropriate use of technology, drug possession or use, burglary, breaking and entry, alcohol possession or use. I know during this last session when you were campaigning, I think it was mentioned here by someone that the concern with student discipline, I know you heard that from teachers, that they seem to be overwhelmed. We believe this bill, if it passed, would make it much more difficult to remove students from the classroom. The cross-examination Jane spoke to just a second ago, had a superintendent in our office this week in the last 2 years, they've had 5 kids come forward and saw a gun in the classroom and went to the authorities and told. All 5 of those, the superintendent said, would not have come forward if they knew their name was going to come out. One of those stopped the shooting. The kid was expelled, said, I was going to kill people that day. A year later, yes, that was my intent, had it not been stopped. Just heard that this week. We agree with the intent. It is extremely difficult to prove. And this is about, anyway, we ask you to, if it comes to a vote, to please oppose this as it is currently written. Now, I do want to say, Representative Estes, you recognize that little Cook kid back there in the back. Now, I know his mom and daddy, and while he's here this week, I hope he acts a lot like his mother. So,
Thank you for your comments, Mr. Hollingsworth. With that, that concludes our public hearing, and I would at this time then recognize Madam Chairwoman Collins again to make any remarks, whether it be in rebuttal or just other additional remarks you'd like to make into what we've heard.
I know that the senator that's worked and cares so much about this has not been successful in the Senate, but I do think there are good reasons to work on this bill. And so I intend for us to do that. And so, yes, thank you, Jane. I would love to see your list of items and any specific ones. I took notes as Mr. Hollingsworth was speaking as well. And Jerome, I just want to thank you for all of your hard work on this all over these last few years. And so what I want to point out, a couple of things that were brought up, though, is that in my opinion, although I'm willing to clarify anything, if anything this year I would like to point out, I believe I've taken more amendments in this 1 year than I might have the last 3 quadrenniums all together. So I am just easy to work with these days. But I believe not putting a witness on this, confronting them, letting them be anonymous is very, very important. And my interpretation of line 145 is that only if they were willing to be there. It says who are present, and I believe that means at that hearing. And so if they're willing to be there, I want us to consider that. I'm not saying I'm hard and fast on that, but it gives a lot of chances for consistent discipline. I agree, it's not often. I do believe it's going to be more and more. And I think consistency is good. And unfortunately, I think in some areas it's less consistent than other areas, which is why I am working with Senator Smitherman. And so I would love to answer and hear this committee's concerns as well, Mr. Chair.
Thank you, Madam Chair. With that, then, I would open the conversation to any of the committee members. Should you have questions of the sponsor or questions of any of those that have spoken before today, then, so I welcome this time any questions or comments. All right, Representative Gray, you're recognized.
Thank you. I just wanted to know about the 246. Was it broken down by race, gender, age? Oh, okay.
Would they have that information?
I believe it is broken down from the State Department. It is reported by and broken out by race and gender and age.
That might be helpful. I'll get that. Thank you.
Any others? All right, Representative Morris, you're recognized.
In the case that you gave an example of a gun, so if a student actually brings a gun to school, would that be turned over to law enforcement to actually deal with, or would that still go through the school to have the students to come in and sit and say that they witnessed that, or would that from there, because it's serious, would that go from the school hand to law enforcement hand?
Representative Morris, if you don't mind, I'm going to let you and then as well. Then I'm going to allow Ms. Jane Williams as well, also as a attorney to be right. I'm going to allow her to make comments as well to that question. Okay, Ms. Williams, if you'll go first, then.
I'm sorry.
Thank you.
So it's actually both. So law enforcement would deal with that issue because it is a gun, but the school still has to deal with the student.
Oh.
It's just like if an employee commits a crime, yes, law enforcement would deal with the criminal aspect of that situation, but the school still has to deal with the employment aspect of the situation. It's the same with a student.
Okay, so
it's still
but
both.
my question is, when they start the process, would they actually bring in the student? Because the statement, the example that was given, that the students wouldn't come forth if they knew they had to come and basically talk about what they actually saw. So would the school then have the right to have the kids come in and testify or give their statement to say that I saw this, or does that go straight to law enforcement?
So let me tell you what I believe would happen.
Mm-hmm.
Okay. So kid goes to the principal and says, there's a gun on campus.
Mm-hmm.
Stop, drop, and roll. The principal calls the police. The law enforcement doesn't then need the kid who reported it to
Okay.
say, I saw the gun.
That's it right there, because that's gonna go with what he just said.
Because you
It
got
goes
me?
straight to law enforcement. Thank you.
Yes, ma'am.
All right.
Thank you.
Thank you, Ms. Williams. Mr. Hollingsworth, do you want to add anything to that? Okay. That's fine. Okay. Representative Pascal, you're recognized.
Okay, thank you, Mr. Chairman. A couple questions. The statement was made, if this bill was enacted, a student in possession of tobacco or they have committed theft or in possession of alcohol, that if this bill was enacted, they would have to go through this process. So my question is, if the student is in possession of a tobacco product, is that automatically suspension 10 days or more? How that process works?
No, it would be up to local student code of conduct. So each Board of Education has a different student code of conduct, and I think that's probably what she's referring to as consistency. So the local control, each board would develop their own. So they're going to have, is it a class 1, class 2, class 3 offense, or whatever terminology the local board is using to divide those infractions. So my point to that was, in the examples I used, was when you look at the proposed bill, it says the student is a threat to others or harm others, and I don't have the bill in front of me. So danger to persons or others, or the $1,000 damage, right? So having it being under the influence of alcohol, is that a danger to others or not? I don't think my interpretation, it wasn't. So that's why I listed the items that I shared with you all.
Okay. And the reason I was asking that question is because you're right. Each local school district have the handbooks, the code of conduct. So it was almost like it was implied that, okay, across the board is automatically 10 days or more, but it varies. That's correct. But also my second question is, if we could get a list of broken down of the 249 suspensions and so forth, we could get a list of that.
How the reason they were suspended.
Well, yes, also the location, the school districts. I don't know if you go down with that.
I don't know if I have that. I think we just had totals.
Okay.
And it would be broken down by demographics.
I'm just
Correct.
curious if that's.
We can ask. We'd certainly be glad to ask for that.
Right. And part of that, I'm just curious if we see in certain regions of the state, or is this a problem throughout the entire state?
Yes, sir.
Okay. Thank you.
All right. You're welcome. Representative Smith, you're recognized.
Thank you, Chairman. I think in the audience, there's probably more out there percentage-wise that have been in the classroom than there are up here that have been in the classroom. And one of the reasons we're struggling to have qualified teachers is we've got people who don't want to go into the classroom because of discipline. However, I don't think this solves it. I think leaving the school boards or tying the school board's hands to specific things is a problem. I remember when I was hired as an assistant principal, I had 2 big manuals. And I thought, well, this is good. If it's this, then it's this. And if it's this, then it's this. Everything's black and white, and there is nothing that's black and white. It's all gray. And every one of those situations can have a lot of the same characteristics, but they're not equal. And I think that the more we tie the school system to a cookie cutter approach, I think the further we get away from common sense being used by administrators. Now, I'm going to tell you, and I was one, all administrators are not the same. And but until we get authority back in the classroom, then we're missing the mark. As long as all authorities in the office, or if it's at the central office, then the kids know I've got 2 or 3 more steps. And so I would much rather see a teacher have authority under the control of the principal, assistant principal in the county system or city system than I would to have some big oversight. And so I don't know, and I appreciate Chairman Collins working on this, but I don't see how you can write something to engage everything that that's going to be faced in education. So I appreciate the effort, but I don't know that we're there with this.
Thank you, Representative Smith. Representative Drummond.
He sort of stole some of the questions that I was going to ask, not exactly in those terms. And I guess it's to Chairman Collins, because the bill calls for a neutral designee. And I'm wondering, how do we standardize that when every situation has different variables? And I just don't see how we standardize. I want you to tell me, how will we do that?
Well, if you
with
remember,
existing law?
because you were here 3 years ago, it was an outside litigation process. So it's pared back and pared back and pared back. And I think neutral, the goal was that someone that was agreed upon by both persons that maybe not was employed by one of the persons. And so that was where we were going. I think that we've heard and may have some suggestions on continuing to work with that, so that there is just like was also mentioned, some type of a process that gives a due process to a student and a family, because sometimes there are more than one side of every story.
Well, and also when you look at our systems throughout the state, whether city or county, I wish all sizes had all resources to do whatever they want, and we know that's not the case in Alabama.
Mm-hmm.
So when looking at whatever you're working on, I hope you keep that into consideration, because, I wish all sides were nice and neat, but it's not that way.
No, I agree. And I think that was where we were trying to go, is that this could look different in every local area. There might be a different person that would fit this parameter that would work. And that's what we were trying to do, is give as much flexibility for the appropriate person in each local education area.
Representative Gidley.
Thank you, Representative Baker. And I think we're all hitting kind of on the same thing here with Representative Smith and Drummond and myself. And you may have touched on that, Representative Collins, Chairman Collins, on what I was going to ask. Let me also just say, to reiterate what's already been said, having those that work close to me that work inside the education system, discipline is not a problem, it is the problem. And it is one of our things that is holding back us being able to recruit good teachers. And so doing something about it is extremely important. But and like I said, you may have hit on this, so I don't want to just keep repeating the same thing, but the statement here that in this very first line of the synopsis, the bill would provide a uniform statewide system of procedural due process protections related to the suspension and expulsion of public school students. That was something that concerned me. I needed clarification on when it said they would provide a uniform statewide system. That was a concern to me, and I think it maybe kind of been hit on here that we can't do a one-size-fits-all. So is that saying what I think it's saying, or is there still the ability for the local school boards to create their own system that's pertinent to them?
my goal with this would be to give as much flexibility to the local school systems as possible, but to have certain parameters that do have to be met in each thing for a due process. And so I guess thinking about it as, how does this one say it, a system, I'm thinking of more a process that everyone uses. And this bill and what we end up doing with it would describe that process.
And I don't disagree that we need some kind of standard, but again, you can't apply the same thing in Etowah County as you could apply in Mobile County.
And it will look different.
Yeah,
correct.
it absolutely will.
Representative Estes.
Thank you, Mr. Chairman. You know the old saying, I think we've all heard it before, you can take the boy out of the country, but you can't take the country out of the boy. And I think that's me here as a former school board member, having served 15 years on the Winfield City Board of Education. With all due respect to the chairman, I do have concerns with this, and they're pretty much the same concerns I've had since we started addressing this bill not long after I took office. I believe local control on these issues. This is a local issue. Every community has a different standard for discipline and what they anticipate out of their school administrators. To me, this is the principal and the teacher's job to take care of this within board policy. I'm concerned about the concept of cross-examination. And as I was reading through this bill the other night, I looked at it and I thought, I don't want to begin treating our schools like a courtroom. And I'm not an attorney, but eventually, if we start treating our schools like a courtroom, we can say what we want about protecting the child. But eventually, there's going to be a smart attorney step up, and there are a few out there, that would step up and say, if this is now like a courtroom, my child and me as his or her parent has the right to face their accuser. And that's going to bring that other child into that courtroom setting. And then all heck's broken loose. So to me, we can change it and amend it and everything else. I just am a big believer, not just in education, but in as much local control as possible, because the folks in that respective community knows what their standards are. And am I a big believer in discipline? Yes, if we want to solve this problem, I grew up in a household with a father named Johnny Estes. If we'd make him principal of every school in Alabama, we'd be done in about 3 days, and we wouldn't be having these problems. But I know times have changed. The family environment has changed. It's not as easy as I would like to believe it is, but I do not think there is ever going to be a one-size-fits-all policy that can fix this problem. It's a community standard issue, and I believe the superintendent and the Board of Education are qualified, either appointed or elected, to draft policies that are current and consistent with community standards. So that's my 5 or 6 concerns with the bill, but thank you for the recognition.
Representative Fincher.
Thank you, Mr. Chairman. I had a couple of things. On page 2, when you get to section 1, there seem to be some loaded adverbs in that I have a problem with. Number 1 there, we rely too heavily on suspensions and long-term expulsions. And Mr. Hollingsworth, I think, brought up a good point. I don't think we do. I taught in the school systems for many years. I did not see that many suspensions or expulsions. It was on a very rare occasion that I saw a student expelled or suspended. So I guess you can argue what is too much or what is too little, but at least in my experience, I don't feel that it is overly used. And then it says removing students is costly. Well, this is going to make it more costly, it appears to me, because you're going to have a system that's going to play out longer, and actually, if we're talking about financially or monetarily, it's probably going to be more costly. Zero tolerance policies have not been shown to improve school climate or school safety. That is akin to me like saying we arrest criminals and put them in jail, and yet crime continues to increase. And that does not indicate to me that we'd be better off not arresting criminals. But the whole general tenor of this seems to be, a little bit and I know you're trying to prove a case when you write a bill and all of that, but the number 5 says fair and uniform systems of procedural due process is necessary, and the word necessary is used there. Is functioning without it right now, so I don't know if it is necessary to run a school. You know, it's there seems to be anyway. Those are kind of some concerns I have with the introduction of the bill. Mr. Deese, could I ask you a question? Where you were talking about under age 14. Could
You'll
you
step to the podium, please. Thank
could you show me where what you're referring to there is?
So that's not in the original language. That's in
Okay.
the amendment that was offered in the Senate companion that will be brought up next
Good.
week.
I knew I hadn't seen it, and so
Absolutely.
I'd read the bill and hadn't seen that, so that's where it is.
Absolutely.
It's in an amendment.
Yes, sir.
Okay. Thank you very much.
It was one that was done in the Senate committee, and so we were going to try to have the bills to match. I would like to respond just a minute. I'm not one that likes to do a lot of declarations. Matter of fact, I don't usually even read that section because it's not the part that's changing the bill. So, and I agree with a lot of these statements, but I understand your point as well. So, are there any others?
No. Okay. Representative Pascal.
Yes. Procedure due process. I heard the young lady mention from a legal standpoint the definition of due process, but as written in the bill, Ms. Chairman, due process, what does that exactly mean as far as in the school setting? Or
Well,
either one of
it would mean whatever we ended up doing in this legislation, as much or as little.
Ms. Williams, if you don't mind stepping forward, thank you.
Yes, sir. Quick law class. Under the U.S. Constitution, all citizens are guaranteed a right to due process. There are different levels of due process depending on how much you're about to lose from the government. Obviously, over the criminal courthouse, you get maximum due process before you're put in jail. If you're about to lose $5, you get a lower level of due process. Students are entitled to a certain amount of due process if they're going to be put out of school for one day. So there are different levels of due process. There's minimum due process and there's maximum due process. So the basic level of due process is notice of what we say you did wrong and an opportunity to defend yourself, to say what your side of the story is before the government, school board, takes away whatever, your right to go to school. That's what we're talking about. Adding cross-examination on top of that, the U.S. Supreme Court has said that is not a necessary component of due process in this school context. And that's what we've been fighting about with that handsome guy back there in the back row for 3 years, is that a part of this due process? Ultimately, y'all get to decide if that's what we're going to have in Alabama, and we're just fighting about if that's necessary. Okay.
Thank you so much, Ms. Williams.
Mr.
Okay,
Chairman.
Representative Pascal.
Well,
continue.
based on that, as we move forward with the bill, would it be a good idea to define that in the bill?
I think it's going to be hard to, what we would be trying to do is to define it for long-term suspension and expulsion. That is the whole thing, not taking away any of those possibilities for a 1 day or for anything less than what we have defined here.
All right. Representative Morris, you're recognized.
I know 200 doesn't sound like a large number, but it just depends on once we get the data to actually see where it's actually taking place. 200 is a lot if it's taking place in certain schools at certain times. So that just keep that in mind. It might not be across the whole state of Alabama, but if you have a certain number that's coming out of a certain side at a high number, then that's way too many.
Thank you to all the committee members for your inquiry, for your comments, your line of questioning, as well to the public as well for being engaged in the process as well with your comments and commentary. With that, then, we have already concluded the public hearing. We've concluded our commentary on the bill. So with that, Madam Chairwoman, you may have some closing thoughts to share with the group. I turn the gavel back over to you.
I'll just simply say thank you very much. I knew this committee would not let me down with a thorough discussion of all legislation. And so I want to say I've taken good notes. I'll try to get information you've requested. But for those of you that are willing to work with me on improving, I would love to hear your comments before Friday. Thank you. We are adjourned.